I'm asked frequently about water and water rights in Utah, and it's a little different. It can be a little complicated. So let's go over some basics. I'm Jennie Hendricks at Century 21 Prestige Realty. And water is kind of a complex and complicated issue in this area. So let's talk about some of the basic information that you need to know if you are going to be dealing with water rights in the area. First, let's talk about sort of the history and how we got to where we are, and I think it'll make everything else kind of fall into place a little bit. Water law began in Utah, of course, with the settlement of the pioneers in 1847. The first settlers in the Salt Lake Valley arrived to a desert where the primary water source was streams coming out of the canyon and the Jordan River. In order to settle the Salt Lake Valley and begin growing crops for food, they had to divert that water to where they needed to irrigate. The law that grew out of that and governing the use of water in Utah was grounded then in the need to move and use water in order to survive. Utah, like most Western states where irrigation is necessary, follows the doctrine of prior appropriation. Okay, the doctrine of prior appropriation. We're going to talk about that a little bit more and what that means. Prior appropriation began as a principle which was just sort of understood, and then it was later codified into law. So the concept of prior appropriation is actually law surrounding water rights now. The two primary tenets of the prior appropriation doctrine are first in time, first in right, and use it or lose it. And if you're dealing at all with water in the state, you're going to hear those two phrases a lot. So first in time, first in right, and use it or lose it. In Utah's earliest days, a right to use water was established simply by diverting the water from the stream or other source and placing it to beneficial use. Okay, now beneficial use is another term that now has legal implications, and we're going to talk about that in a minute here too. So the earliest way to get the water or to establish the right to use the water was diverting the water from its source and putting it to beneficial use. The principle was established that the first person who made the beneficial use of the water should be entitled to the first right to use that water, with a preference over those that came later. This became the primary tenet of the prior appropriation doctrine, first in time, first in right. While the right to use the water could originally be established simply by diverting the water from its original source, putting it to beneficial use, it's important to remember that it was only the first right which was obtained. So the water resource itself was still considered a communal resource. And that's important when we start talking about the use of the water, appropriation of water, beneficial use of water. So the water resource itself is still considered a communal resource that had to be administered for the good of the community. And the law evolved from that, and today the water resource is the property of the public, subject only to existing rights to use. And that really underlies all of the laws surrounding water rights in Utah. Water is considered public. You have the right to use it, but the actual ownership of the water is still considered to be the property of the public. It is also clear that the limit of the water right obtained is its beneficial use. Since a water right only establishes the right to use the water, which is owned by the public, failure to use that right can result in the loss of the right and the reversion of that resource back to the public for beneficial use by another party. Thus, the second tenet of prior appropriation, which is use it or lose it. So in 1897, which is 50 years? Yeah, 1847 is when the pioneers first got here. So in 1897, the Office of the Utah State Engineer was created to administer all of the waters of the state. The first complete water code was enacted in 1903. In 1903, when the water code was enacted, they really didn't understand the relationship of groundwater and its connection to surface water. So as a result, most groundwater could continue to be appropriated without filing of an application until 1935. In 1935, the Utah Supreme Court held that all groundwater, like all surface water, was subject to the appropriation laws. So I'm not going to get into this in a lot of detail right now because we could go on for a long time about water. But if you get into water, you'll find that that date of 1935 is really significant when you're dealing with the chance to lose the right to that water. So priority date is important when you are talking about using water and having rights to the water, and that date of 1935 becomes really significant. So since 1903 for surface water rights and 1935 for underground water rights in the state of Utah may only be obtained by application and permit from the state engineer. So you'll remember I just told you that originally all you had to do was divert the water from its source and you were considered to have the right to use that water. That changed in 1903 for surface water and 1935 for groundwater. The process and right to appropriate water, either surface or ground, is governed by statute, administrative rule, and policy. So there's a lot of ways you can get sideways when you're talking about water rights. The process to appropriate a new water right in Utah begins with filing an application with the Utah State Engineer. The application requires identification of the quantity of water sought, the source of the water, and how the water will be used and where the water will be used. Where the water will be used is also called the point of diversion. It's usually a well. So if someone is drilling a well, that is called the point of diversion for the water from whatever particular source. If an application to appropriate water is approved by the state engineer, the approval itself does not create the right to use that water. It's sort of like the first step in the process, okay? A water right must be certificated before it becomes a vested right. Think of it like a hunting license, okay? So the approval gives the applicant the right to attempt to capture the water and place it for beneficial use, but it does not guarantee a successful outcome. You can go attempt to get the water, but just having that approval does not guarantee that if you sink a well, the water is going to be there. To obtain a water right certificate, the vested right to use the water, the applicant must prove to the state engineer that the water has been diverted and beneficial use of the water has been sought. It's kind of complicated. That's also called proving up the water. So you'll hear that phrase a lot too. So people say, okay, has that water been proved up? That just means, has that water been put to beneficial use? Can it be demonstrated that someone is using that water beneficially for crops, for household use, for animals, for whatever? So once the water right has been proved up, proof documents will be submitted to the state engineer, and those include maps showing the location of the completed works or the well, the point from which the water is being diverted, and the place where the water is being beneficially used. All of that has to be submitted to the engineer and approved in order to say that that water right has been proved up. So now we know sort of the history and the process to put water to beneficial use and to demonstrate your right to use that water. How do you prove that you have the right to use that water? Well, Utah statutes provide that title to perfected water rights passes by a deed in substantially the same manner as real estate. So if you're involved in a transaction where there's real property and water rights, you're going to get a deed, of course, for the real property and something that is very similar to that to demonstrate ownership of the water right. Now, there's a couple of different ways that water can transfer. So if the water is appurtenant to the land, which means does the deed to the water and the deed to the land run together? If it meets the legal requirement of being appurtenant, it will automatically transfer with the land deed. Water rights can also transfer independently, so they don't have to be appurtenant to land. In fact, water rights are bought and sold all the time. They have their own category in the multiple listing service. You can buy a water right, and transfer it if you go through the appropriate documentation with the state water engineer. But anyway, there's two ways basically water is transferred. It can run appurtenant to the land, or it can be transferred independently with its own deed. Deeds and other instruments affecting the title to water rights are to be recorded with the county recorder where the water is diverted, or where the well is drilled, of course, you'll remember, as well as having the proper documentation filed and approved by the state water engineer. This is a step that some people miss, okay? There's two separate processes that have to happen to transfer the deed or the title or the right to use that water. It has to be recorded at the county, and it also has to be properly transferred at the state water engineer. The Division of Water Rights ownership records must be current before an owner can take any action on a water right, such as an application to change the right. Often, the water right ownership records have not been updated with the Division of Water Rights. It is unfortunately not uncommon to find water rights whose ownership records have not been updated since the right was originally appropriated or decreed. In such cases, the burden is on the current owner, usually the most recent buyer, to provide the Division of Water Rights a record of the complete chain of title from the owner on record with the division to the present owner. So I'll just tell you, practically speaking, what happens is if water is transferred and it is not appurtenant to the land, if you're just transferring those water rights, it's typically done at a title company, just like land is handled by the title company. And so the title company will record it with the county. There is nothing that requires the title companies to also record that with the Division of Water Rights. That is up to the buyer to make sure that those records have been updated with the Division of Water Rights. Sometimes people aren't aware that they need to do that. And so you might have multiple people in a chain of title or chain of ownership that have not sent the proper documentation to the Division of Water Rights. And it can be kind of sticky to go back in time and try and figure out that a chain of ownership. It can be complex and it can be expensive for the current owner. I want to emphasize you can get title insurance for water rights, just like if you are purchasing a piece of property, you ask the seller to pay for a policy of title insurance that insures you as the buyer from the point of closing into history, okay? So that you've got evidence of a clear chain of title and no liens, encumbrances, that sort of thing. It's a really similar process with water rights, okay? So you ask the title company to provide a policy of title insurance for this water right. Sometimes a seller will pay for it. Sometimes a buyer says if the seller doesn't want to pay for it, the buyer will just say, it's important enough to me that I want to have that done. I can't emphasize enough how important this is when you're dealing with water. Now, having that title insurance policy does not guarantee that you're going to be able to use the water. It doesn't guarantee that the water is there. It doesn't guarantee that if you sink a well, you are going to hit water. What it does is guarantee that chain of title and that the proper transferring has been completed. And I will tell you a story. I was involved in a transaction years ago where a seller on a particular right of water had sold it multiple times. Well, one person got title insurance and nobody else got title insurance on that water. And so this one person who went to pull a well permit, and then it came out that there was an issue with title, an issue with ownership. This party was able to file a claim on that title insurance and they won. So just like having title insurance on real property is kind of a big deal, title insurance on water rights is something that I don't see used as often, but really is equally important. So yeah, the division of water rights ownership records must be current before an owner can take any action on a water right, such as an application to change the right, drill a well, anything that change the point of diversion, anything that you want to do to put that water to beneficial use. Okay, so that's a lot of history, a lot of information, and I am just barely skimming the surface here. So there's a lot more depth to all of this. And I really encourage you, if you are getting into water rights, if you're purchasing land that has water or you're just purchasing water rights, you really need to do a deep dive into this stuff and have a great understanding of it. But practically speaking, what does this mean for you? Well, if your water is being delivered to you via a municipality like Cedar City or Enoch, or maybe the Central Iron County Water Conservancy District, you really don't have to worry much about water rights. The entities that are delivering the water to you already own those water rights and they're charging you for the use of those, essentially. If you are on a community well, which there are several in the area, you will likely own shares in the community well. You probably will not own rights to the water that is being pulled through that community well. It's set up as a corporation and you'll have a certain number of shares in that corporation that allow you use of a certain amount of water. So for example, 1 share of water might equal 1 acre foot. 1 share of water might equal 2/3 of an acre foot. Each community well is going to divvy up the water according to how much water is owned and the uses in the community. Now, if you are on a shared well or a private well, you do need to be pretty well versed in water rights in Utah. It can be complicated, so please be sure you're asking a lot of questions of the appropriate entities. So if you are on a shared well or a private well, you do have to own the rights to the water in order to pull it through that well. You can't just buy a piece of land and sink a well and start pulling water out of the ground. You have to actually own that water. That water has to be approved to be used at that point of diversion, and then you have to prove it up. Basically show that you are putting it to beneficial use. So if you have a shared well or a private well, this is really important stuff. Now, I also get questions frequently about the measurement of water. So I've been talking about a certain number of acre feet of water. Okay, that's sort of the term we use when we talk about the measurement of water. So what is an acre foot? Well, visually, an acre foot is enough water to flood a football field about a foot deep. But practically speaking, it's used to measure what you can do with the water, right? For example, for household use, you will need 0.45 of an acre foot. So just under a half of an acre foot, 0.45 of an acre foot of water. If you're going to have animals, there's a formula for how much water you need to have large animals like horses and smaller animals like goats and chickens. And so you talk to the Division of Water Rights, and it's on their website, and you can get the whole formula to figure out how much water you need to do what you wish to with your property. If you are going to have land in production, there's a requirement of so many acre feet of water per acre of land. For example, if you're going to grow alfalfa, you'll need 4 acre feet of water for every acre of land that you have in production. And of course, there's some caveats there depending on the area in which you're growing and different things. But generally speaking, alfalfa takes 4 acre feet of water for every acre of land that is in production. So, water in Utah and in the West really has a long and storied history. The saying around here is whiskey's for drinking and water is for fighting. Please let me know if I could be a resource for you. This is a complex issue. I'd love to help at least point you in the right direction to get the information that you need. Thanks for hanging with me today. I'm Jennie Hendricks at Century 21 Prestige Realty. We'll see you soon.